Good morning. May it please the court, Suzanne Keffer from CCRC South on behalf of Mr. Patrick. We're here today after remand by this court to consider whether or not trial counsel exercised a reasonable strategy in keeping an actually biased juror on Mr. Patrick's jury. After that evidentiary hearing, the trial court found that there was a reasonable strategy, and I would state that the trial court was incorrect. The entirety of the record in this case simply does not support an objectively reasonable strategy. First, trial counsel offered that his reason for keeping this juror was that he was not biased toward Mr. Patrick. He stated the reasoning was Mr. Patrick was not a homosexual, and therefore the bias did not extend to him. As this court knows, this court has already rejected that reasoning. This court found before remand that Juror Martin was an actually biased juror, that bias extended to Mr. Patrick as well as extending to the victim.
I thought, though, that, I'm sorry to interrupt you, I thought, though, that, so that was the rationale that we rejected when we found that the biased juror standard had been established in our last case. But here on the remand, I thought the record was that the rationale for keeping this juror was that, you know, A, it could possibly lead to a life versus death, and B, that this juror's feelings about homosexuality could actually help the defendant in the sense that he would find the behavior that led to the killing, you know, to be so offensive to him that he would actually potentially sympathize with the defendant. I mean, so I thought we were beyond the idea of the distinction between whether the defendant himself was homosexual.
Well, I don't think that we were, in the sense that trial counsel actually said that exactly what this court rejected. His initial response, his initial strategy was, my client was not homosexual. This was favorable to him. The court has already said that it was not favorable, regardless of Mr. Patrick's orientation.
I actually thought that we said that that could not be determined without an evidentiary hearing.
You stated that there may be strategy reasons for, but what I'm saying is the very initial reason that, and I want to get to the second suggestion that counsel made as well.
This came to us is a summary denial in the first instance, and the arguments were made similar to what counsel testified to, that this would have made sense to leave this juror on for these reasons based on the record. And I understood the first opinion is simply saying that, you know, that's just not the kind of determination you can make without an evidentiary hearing. You can't assume a reasonable strategy, even though an apparent reasonable strategy could be shown from the record, because it just the kind of thing that requires an evidentiary hearing.
Correct, and I agree, and we went back for the evidentiary hearing.
Right.
However, what I'm stating is that his initial reaction was exactly what this court rejected and said is not, that was the state's reasoning in the last argument, is that this was reasonable because this juror was not biased toward the defendant. This court rejected that reasoning.
Well, we rejected that as a finding that you could make as a matter of law based on a cold record, but we sent it back for an evidentiary hearing, which sort of assumes that it could be established as a matter of fact.
I think that what the court, because that was one of the reasons the state suggested. The state suggested also that this juror may have been more favorable for the penalty phase. And that was the second reasoning that trial counsel gave. As Justice Munoz said, is that he also suggested. So my argument is that this court has rejected his initial suggestion of strategy, that this defendant was somehow not disfavorable to Mr. Patrick. But the second suggestion that this juror, he kept this juror on because he was more favorable towards the penalty phase, was more inclined for a life sentence, is also refuted by the record. The fact of the matter is...
I just one question about the facts of the case. Mr. Patrick gave a statement to the police upon his arrest, am I correct?
Correct.
Right. Somewhere in the facts, and I'm trying to determine when the jury heard this, if the jury heard it at all. The facts were that Mr. Patrick admitted that on prior occasions, not this instance, long before this happened, prior occasion he had picked up men at gay bars, and allow these men to perform, sexual acts on him. That's long before, or not before this incident happened. Did the jury hear that?
I believe that's part of what his statement was to the police. And the statement was played at trial at the guilt phase for the jury.
So if a strategy basically is that I want to keep this guy on the jury because he's going to be so offended or so taken back by the fact that the victim in this case made a move that the defendant didn't like, and the defendant reacted out of rage, out of indignation to that, then that wouldn't fall very well if the jury heard that a few weeks before or whatever he was picking up men and having homosexual relationships.
That's correct, and I think that's part of why this court rejected that notion that this juror wasn't biased toward Mr. Patrick. Mr. Patrick had engaged in homosexual relationships prior. He was engaging in a homosexual relationship with the victim in this case, and in fact, Mr. Rears' statement that this juror was favorable to the defense is undermined by the trial record. Mr. Rears was arguing at trial in opening and certainly in closing argument. In closing argument, he made statements that this relationship was similar to a heterosexual relationship, that it was no different, and they shouldn't look at it any differently because this was two men. So that certainly cuts against what Mr. Rears asserted at the evidentiary hearing. I want to point out very quickly, too.
The counsel, that's not the tenor of what the defense was. The defense was that the defendant here deserved less than premeditated murder because this was a immediate response to being propositioned by the victim in this case during that specific day, that there was something different in kind from what happened earlier that set the defendant off in this case. That was the defense, right?
The defense was for the lesser. But
based on the theory that I've just articulated, correct?
Yes, that they had been engaging in a homosexual relationship. They had
engaging in some sex acts.
That there was an
correct.
that there was an
in
exchange.
this instance,
That there was an
they set him
exchange.
off.
That there was an exchange of a living arrangement for the commission of sex acts on the defendant, and that the victim wanted to take it a step further, which set the defendant off, resulting in the murder. That's the defense.
The victim wanted to move things further along, but
Is counsel, what I articulated, was that the defense?
the defense was for the lesser because it set the defendant
Okay,
off.
because
but
he
you
wanted
have to consider the arguments of defense
something
counsel.
because he wanted something different than what had been previously going on. Correct?
Yes, he tried to do additional sexual acts
Right.
with Mr.
Okay.
Patrick. However, you have to look at what was argued by defense counsel.
I understand. So, counsel, given that that's the defense, how is it unreasonable at the time for a juror who says, I am biased against homosexuals and think badly of them, that the victim in this case acted consistent with that bias? How is that an irrational thought by counsel in this case?
Well, again,
Or not strategic thought?
Again, if you look at the opinion of this court previously, all 7 justices rejected that.
Put aside the
Second,
prior,
I will say
put aside the prior opinion.
that it is
How-
also unreasonable because trial counsel, every other juror who expressed a bias against homosexuals was struck from this jury.
Except-
and counsel
But
agreed
counsel,
without objection.
but counsel, none of those jurors like this one also stated that they had such a favorable view of imposing life as opposed to death. This was the only juror that had both.
And I can talk about that too.
Am I
and I
cor-
find that unreasonable.
Counsel, am I
as well.
correct? Am I correct that this is the only juror that had both?
I believe that juror Cohn, and I don't know if I'm saying that right, but in the record it's Koehn, he expressed bias towards homosexuals. I don't believe that he fell one way or the other in terms of the penalty phase.
But the juror
And-
here was very specific about the penalty phase, that hearing voir dire, he had such an awakening about the death penalty that he thought that he was reflecting on his own views on it. I mean,
Again, under these circumstances, and if you look at the entirety of the trial record, which I suggest the lower court did not do, it was unreasonable to keep a biased juror in that scenario too. The fact that this juror was more inclined to a life sentence does not get rid of the bias. This juror was still impartial.
But I'm sorry,
trial counsel,
I'm sorry to interrupt you. Can we just for the baseline though, for the prior opinion, my understanding of the prior opinion was that it left open the possibility that it could be reasonable to keep a biased juror on the panel. So my understanding of the prior opinion was that we accepted the premise that prejudice had been established, prejudice in the sense of having a biased juror on the panel, but that if there, if there's sort of a complicated thought process that, yes, this juror is biased against homosexuals, but this bias could actually combined with the penalty phase and given the particular facts of this incident that led to the homicide, that if you put it all together, that it could be objectively reasonable for counsel to have allowed this person to be on the jury. I mean, and that's what I thought that that the evidentiary hearing was supposed to be
And I agree
about.
that would have been a very complicated thought process that trial counsel would have had to consider. There is
But
no
isn't that,
evidence
but
in
I'm
this
sorry,
record.
I'm sorry to interrupt you, but isn't that what the purpose of the remand was
I
to
think this
was
court
to look
did
at
leave
that?
that open.
Not just leave it open, that was
Yeah.
the whole reason for the remand.
Correct, and what I'm stating now is that if that complicated thought process had taken place, which it did not, there is no evidence in this record that trial counsel engaged in any sort of weighing. In fact, trial counsel had no independent recollection of Juror Martin, of what he said,
Well, he
or
testified.
any of the other jurors.
He did testify as to his general strategy. He didn't have a specific recollection, but he testified as to what he would have been thinking based on what he knows about how to try a case. And
was
that's the kind of
complete
testimony.
speculation.
That's the kind of
And it's-
testimony we found has been sufficient to support a finding
Well,
of
in
strategy.
this instance,
I mean,
it
how
was
is it-
only after being shown the record that he then said, oh, this juror was inclined for a life sentence. He didn't even remember that to begin with.
Well,
And
but
so
it
was
refreshed his
speculation.
recollection. It refreshed his recollection, but I mean, this is an individual who had tried 22 or 23 capital cases. This is not an individual who had only tried one case, one capital case, or had tried none. I mean, this is an individual who had experience, and when his recollection was refreshed, he said, that was a person that was favorable for the defense because he preferred a life sentence over a death sentence.
Well, his recollection was not refreshed. He simply said, oh, I see that statement now here in the transcript, but I have no independent recollection of this at all. I think, too, as an experienced trial attorney, he was obligated to weigh these two statements against each other. And again, there's no evidence that that was done at the time of trial. His notes don't even reflect the biased statement that Juror Martin made. It's not there. And also, as another aside, he didn't include notes that Juror Martin said that he would have looked at whether or not a witness, if they were using drugs, they would be less credible. He didn't have either of those things, two very important, relevant information from this juror that should have been considered at the time of trial. And there's just no information that weighing happened. The other thing that indicates that no weighing had happened is that his two reasons for keeping this juror on the jury are opposing vantage points. At one point during the evidentiary hearing, he says, oh, it would seem that this juror was a better juror for the penalty phase for me. Well, that's not what he said in the beginning. What he said in the beginning was, oh, this juror wasn't biased towards my client. He was favorable towards my client. Those are two opposing vantage points. Either he conducted that complicated weighing process and determined that despite the bias, I find his comments about the gravity of making this sort of decision and that he would be more inclined to life, that outweighed that. But he didn't do that.
Why are those inconsistent? Why couldn't he have determined that the bias would have weighed in favor of his client as to his theory on guilt, and that the juror also would have been favorable for the penalty phase? Why are those inconsistent?
Well, he could have, but it was his comments at the evidentiary hearing saying, oh, well, sometimes I need to keep unfavorable.
How long ago was the trial?
The trial was in 2005, I believe.
Okay.
I'm sorry, the crime may have been 2005 and it was 2009. I understand it was a while back, and that's part of the problem with this, is that, again, he was speculating. He was looking at a record and coming up with post hoc rationalization as to why he kept this biased juror on. That weighing process did not happen, and the reason those are opposing vantage points, if he had stayed consistent throughout the evidentiary hearing and said, well, he wasn't biased towards my client, and he also was favorable for a life sentence, that's why I kept him. He was a winner all around for my client. That's not what he said. He switched views and said, well, maybe he wasn't good for the guilt phase, but it looks like he was good for the penalty phase.
Counsel, you're now in your rebuttal time.
I'll save the remaining amount of time.
May it please the court, Lisa Marie Lerner with the Attorney General's Office for the State of Florida. Given the overwhelming evidence of guilt in this case, trial counsel decided to focus on the penalty phase as the primary test for potential jurors, while also not neglecting the guilt aspect of the trial as well. And Juror Martin was an excellent penalty phase juror. Both trial counsel Raris and trial counsel Ferraro said that. Ferraro didn't have any memory, but when she looked at his statements, when they tried to refresh her recollection, she said it didn't refresh her recollection, but she read him as being a very middle-of-the-road, not pro-death juror, and that's the type of juror that they were looking for.
There's also some independent evidence of the testimony to support this, is there not? Wasn't there the notes that were submitted in evidence?
The notes that...
The notes from jury selection from Mr. Rares.
Yes.
And in fact, it had a note about something about having him off, and that was crossed out, was it not?
Yes.
And there was testimony from the colloquy and from the testimony there that the defendant here was extensively consulted regarding jury selection.
Yes. In fact, that's the one fact that Ms. Ferraro recalled, was that Mr. Patrick was actively engaged in discussing the jurors with the trial counsel and in deciding who remained on the juror. If Patrick wanted someone on the jury and the trial counsel didn't, and they couldn't change his mind, they kept that person, and vice versa.
But is the point then that there was some discussion that happened between counsel regarding this very juror, because there was at least some skepticism, and then it was crossed off to discuss why this juror would be a good juror or not, correct?
That is correct, Your Honor.
Doesn't that exactly support what the trial court found in this case?
Yes. Yes. And as the judge in her order pointed out, Juror Martin focused on the enormity of the responsibility of sentencing someone to death. And that aspect is what Attorney Raris called golden. He is a winner for any death penalty case, the type of juror who would sit there and ruminate in front of the rest of the jury about the seriousness of the decision that they might be forced to make. And Raris also said that he saw this juror as the type of strong juror who could lead other jurors over to a life vote.
But, by the way, didn't that happen here?
Yes. Given the fact that this is a very heinous and cruel death, they got a 7-5 jury vote.
And in fact, the sentence was vacated as a result of that, correct?
Yes. And finally, Raris testified that in over 300 jury trials, he is a very experienced attorney. He has never left a juror on without a strategic reason. And he outlined those reasons for the trial court. The trial court found him credible, believed him, and denied relief. And the state asked this court to affirm that denial of relief.
I want to point out that the strategy that Juror Martin was favorable towards the penalty phase is also undercut by the record in this case. Mr. Rares struck 2 jurors who expressed very like-minded views about the penalty phase, did not express the bias that Juror Martin expressed. Juror Amparo and Juror Vizcarra. Amparo is the one that initially made the statements about life being a harsher punishment than death, and that this was a decision that should weigh upon anybody. And Vizcarra, after some thought, said he was very much middle of the road and could apply the law.
What does the record show
struck.
about those, the decision to strike those?
I'm sorry.
What does the record show about the decision that was made to strike those?
They were struck peremptorily. by trial counsel.
So does the record show any, were there questions asked about that? So that's not developed.
I
at all.
did ask Mr. Rares.
For all we know, the defendant could have said, I don't like that. I feel bad about that one.
Well-
And that is that the case?
I asked trial counsel about that during the evidentiary hearing about both of those jurors, and again, he had no specific recollection about those jurors. He did acknowledge that Amparo had made those statements in the record about favoring a life sentence over a death sentence, and he simply said there's a myriad of reasons why somebody could be struck. But if you look at the record in this case, there is nothing glaring as to why these two jurors would have been removed peremptorily.
But counsel,
they were exactly what he's saying his
counsel,
strategy was.
Wasn't Juror Martin's statement substantively different than Mr. Amparo's for two reasons? One, the statement about bias. In other words, the counsel wanted the biased juror because of the defense, the unique defense in this case. And second, the statement, the way that I understand it worked was that the counsel asked, Mr. Martin, how do you feel about what Mr. Amparo said? He said, I agree, and then went on a colloquy to state that he was having a personal awakening, I don't know the exact word he used, but a personal reevaluation of his view, which was substantively different, it seemed, than what Mr. Amparo said, right?
I'm not sure that it was a personal. He definitely said, "I agree with Ms. Amparo." I don't know if it was if those were the words he used. He did talk about the weight and the gravity of having to sentence somebody to death. Yes, but again, given the totality of the record in this case and the fact that Mr. Rares was still fighting.
Counsel, I want to read it. It's from page 665, 666 from volume 7 of the transcript. Asking if he agreed with Mr. Amparo, Mr. Martin said, honestly, I don't think any of us here want to bear that burden when we leave here, when he's found innocent or guilty, of thinking, wow, I just sent somebody off to be executed. Oh my God, I hope we all make the right decision. Or life in prison, he has his whole life to think about what he did and climb the walls and torment. I don't know. I would be tormenting myself, trying to put myself in his shoes, in the meantime thinking what he may be thinking.
Right, that's what I said, is he felt the gravity
Counsel,
of this decision.
Counsel, absolutely.
Yes.
Counsel, isn't that substantively different than Mr. Amparo and Mr. Viscaro said?
I think that it maybe goes a little bit further in recognizing the gravity of this decision. But again, you had the bias of Juror Martin. So you have to look at the bias, which if we go back and we look at the opinion of this court before, it was the state that said this was a valid strategy because he was favorable to the defendant, because the defendant's not homosexual. This was rejected by 7 justices. So if you consider that you have Amparo, who favors a life sentence, and you have Viscara, who really was going to take the task at hand and follow the law, and he was middle of the road, that's if you're going on the strategy that he was looking at jurors that are favorable for the penalty phase, those 2 jurors fit the bill. Those 2 jurors, without any sort of bias involved, fit that strategy, and he struck them peremptorily.
So your argument really is based on a reading of our prior opinion, that opinion says that this cannot be a reasonable strategy as a matter of law.
It says it rejected the state's opinion, and I think it was saying that there may be other strategy reasons, and that's why we're remanding. But it rejected the notion that in any way Juror Martin's bias, and again, he said that homosexuals, he believes they're so morally depraved that they would lie, cheat, steal, kill, that in any way helped the defendant. It not only extended to the victim, but it extended to the defendant. So it wouldn't be reasonable for counsel to say that his strategy was to somehow keep this biased juror on. And despite the fact that he said he was more inclined to life.
Your time has expired.
I would simply say the totality of this record, when you look at what trial counsel was arguing at trial, it cuts against his answers at the evidentiary hearing. He was fighting for a lesser in the guilt phase. And the fact remains that regardless of Juror Martin's opinions about the penalty phase, he was an impartial juror. This court found he was actually biased. As such, it was not reasonable strategy to leave him on Mr. Patrick's jury. Thank you.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.